Welcome everyone and happy Data Privacy Day. And if you were wondering, yes, it is a real thing. The day was first recognized in Europe and was officially noted by resolution in the 2009 Congress in the United States. So in order to recognize the occasion in Washington, we are excited to welcome Jennifer Lee, Technology and Liberty Manager for the American Civil Liberties Union of Washington, and Kelsey Finch, Senior Counsel from the Future of Privacy Forum. Jennifer advocates for state legislation to regulate powerful surveillance and AI-based technology. She leads the ACLU Washington's work advocating for implementing community-focused policies related to technology, privacy, and civil liberties. A key focus of her work is organizing a tech coalition that centers on race, equity, and the voices of historically marginalized communities. She is working with researchers, activists, and technologists to develop community-based capacity building, counter surveillance, and AI policy toolkits. And Kelsey Finch is a senior counsel at the Future of Privacy Forum and represents the FPF for Seattle, Washington. Kelsey leads FPF's projects on smart cities and communities, data de-identification, ethical data sharing and research, and other select projects, and serves as an expert and thought leader across the country through speaking engagements, media interviews, and interaction with local, state, and federal regulators and strategic partners. Her work has been published in the Cambridge Handbook of Consumer Privacy and the Fordham Urban Law Journal and Santa Clara Law Review. So I just want to extend a big thank you to both of our speakers for joining us today to share their experience and expertise in the areas of privacy, with a particular focus on privacy and equity. And following Jennifer and Kelsey's presentation, depending on time, Matt King and I will also provide a brief update on bills we're following this legislative session related to privacy. So at this time, I will turn it over to Jennifer. Thank you.
Thank you so much, Katie, for that introduction. And I'm so excited to be here today on Data Privacy Day, which is a very fitting day to talk about privacy, surveillance, and power. As Katie mentioned, I lead the technology and liberty work at the ACLU of Washington. And the overall objective of this work is to protect and advance people's civil liberties and constitutionally protected rights in the face of game-changing technology. Key issues and legislation we've been working on include face recognition, data privacy, and AI-based automated decision-making systems. Next slide, please. So a key goal within our overall objective of protecting people's rights is to make technology accountable to people, and particularly the people and communities that have always been disproportionately impacted by surveillance. We do this by pushing for community-centric policies and laws that create safeguards around data and technologies, or sometimes we advocate to stop use of them altogether if appropriate. Where existing laws are unjust or have been violated, we conduct strategic litigation with our legal team to remedy harms. And finally, we convene the Tech Equity Coalition to organize with communities and individuals working to hold technology accountable and to lift up the voices of communities that have been historically disempowered in decisions about if and how technologies are deployed. The Tech Equity Coalition consists primarily of individuals and organizations representing historically marginalized communities, but this coalition also includes privacy advocates, technologists, artists, and researchers who all bring tremendous value to our collective advocacy. What I think is really important about the work we do in Coalition is that we emphasize that the harms caused by surveillance, privacy invasions, and unchecked technologies are not new or surprising. In our conversations with lawmakers and in conversations like these, we emphasize that at its core, surveillance has been and will always be about power and control. It's important to ask questions about who has the power to watch and police whom, with what tools, and for what purpose, who is impacted and who is not. Next slide, please. So here's a brief overview of the presentation I'll be giving today. I'll be first sharing examples of how privacy has not been afforded to people equally throughout history, how the technologies we see combating systemic racism and inequities. And lastly, I'll be sharing some steps we can all take to advocate for equity. Next slide, please. To start us off, I want to share an assumption that often underlies the conversations that we have about technology policies and technology regulation. And that assumption is that technology will fix our societal problems and make people's lives better and not worse, even if there are some costs. Next slide, please. Every day we are bombarded with headlines about the promise of artificial intelligence revolutionizing the way we hire, the way we do our work, get our healthcare, travel, educate, and police. And technology seems really beneficial in so many ways. It makes things faster, cheaper, and more interconnected. But the question that we need to ask is, does making things faster, cheaper, and more interconnected mean that it makes things better? And if the answer is yes, we need to ask, for whom is it better, and who gets to define terms like benefit and cost? Next slide, please. I think this is a really important question to think about, because much like anything that is designed by humans, technology isn't neutral. Technology is not some valueless tool that can be used for good or evil. Every technology by design reflects a set of value choices made by people, and often people in positions of privilege and power. We can see this not only in the way we design technology, but also in the way we design everything else around us. At the top here are bolts installed on steps in front of a building in France, and below that picture you can see bars segmenting this long bench in Canada. And these are just a few examples of hostile architecture that deter rough sleepers and the homeless population from being present in public places. There is a motivation in the way the objects around us and the culture we breathe have been forged. And similarly, there is motivation in the way all technologies exist. There is no neutral way to build a given technology, because humans who hold different values, biases, and incentives build these technologies. And when a technology's design, existence, and purpose are fashioned without direction from those who have been historically disempowered, technology will undoubtedly serve to exacerbate existing structural inequities. Next slide, please. So when we talk about how to build and regulate powerful AI-based and data-based tools, it's important to recognize that there is a long and ugly history of technologies being designed and deployed to target, surveil, and harm those most vulnerable in our society. Technologies, however rudimentary or advanced, have always disproportionately impacted communities of color, religious and ethnic minorities, sexual and gender minorities, and other marginalized communities. We can't ignore that surveillance and the consequent privacy harms have oppressed and continue to oppress marginalized communities. But powerful technologies are continuing to be built and deployed at increasing speeds in the context of this deep inequity, and often without adequate consideration of the impacts that it will have on people. Next slide, please. What we've learned from history is that surveillance technologies serve as tools for those in power to control and monitor those most vulnerable, whether or not the technology was originally designed for that purpose. So I will share some examples of many throughout history of this occurring. And these are just a few of just so many examples, but I'll just name a few salient ones. Next slide, please. So starting with the 1700s, just within this presentation, in 1713, New York City passed what was called a lantern law, which required only Black, mixed, and Indigenous people to illuminate themselves by carrying a lit candle at night, which was the technology of the time. Lantern laws were an early form of surveillance that incentivized and made it possible for white people to enforce slave systems and incarceration. As Simone Brown explains in her book, Dark Matters, lantern laws deputized any white person to stop those who walked without the lit candle after dark. This is the 18th century legal framework for stop and frisk policing practices that were established long before our contemporary era. I think we can all say that candles are neither advanced nor high tech by today's standards, but this is a tool that was weaponized by people in power as a surveillance technology to strip Black people of privacy and fuel the slave patrols and the policing of Black bodies and lives. Next slide, please. Moving to the 1930s and 40s, the US government subcontracted with IBM, which provided its Hollerith census tabulation punch card machines to surveil and target Japanese Americans via census data. Japanese Americans were surveilled and put on custodial detention lists for nearly a decade prior to being unconstitutionally incarcerated during World War II. The US government and the census used Census Bureau information to determine where Japanese Americans lived on the West Coast in order to remove them from their homes and imprison them. Internal government documents uncovered by researchers after this occurred revealed that the Census Bureau gave the Secret Service in 1943 a list of the names, addresses, and the citizenship status, as well as other personal information of people of Japanese ancestry. And this was, of course, heinous, not to mention unconstitutional. But today, government agencies hold more data than could ever be imagined, and that information not only has potential to harm, but actually is used to surveil people every day. Next slide, please. In the 1950s, the FBI launched a domestic intelligence program that many of you are probably already very familiar with, called COINTELPRO, that quickly evolved into an effort to suppress domestic political dissidents through an array of illegal activities. This program targeted numerous nonviolent protest groups, political dissidents, and civil rights leaders like Martin Luther King Jr. with illegal wiretaps, warrantless physical searches, and an array of other dirty tricks. The FBI used the information it gleaned from these investigations not for law enforcement purposes, but in the FBI's own words, to, quote, break up marriages, disrupt meetings, and ostracize persons from their professions. We celebrate Martin Luther King Jr. today, but we can't forget that he was the subject of an intense FBI surveillance campaign. Today, we see similarly disproportionate scrutiny and police surveillance of Black Lives Matter protesters who are advocating for racial justice. Next slide, please. Now, moving into the 2000s, the passage of the Patriot Act in October of 2001, weeks after 9/11, and other surveillance programs launched shortly thereafter have enabled many surveillance abuses and have resulted in direct harm to and anyone who could even possibly be conceived as being Muslim, even if they're not. The Patriot Act has enabled many surveillance abuses, and it was always more about expanding surveillance than it was about fighting terrorism. We can see that because the US government collected Americans' phone records in bulk long before it used Section 215 of the Patriot Act as justification. And what the Patriot Act did was legitimize invasive, suspicionless, and discriminatory profiling of already over-surveilled communities. And even after a decade, Muslims were being illegally targeted by the New York Police Department, whose officers used powerful technologies like automated license plate readers to collect photos and license plate numbers of people at mosques and warrantlessly surveil innocent community members. the NYPD mapped where members of the Muslim community lived, stationed cars outside of mosques, recorded license plate numbers, worshippers attending services, placed remotely controlled cameras on light poles aimed at mosques, and even recruited so-called mosque crawlers to act as inside observers in mosques. The NYPD also placed thousands of innocent New Yorkers in secret police files, tracking individuals who changed their names. And through the surveillance, the NYPD placed unwarranted stigma and suspicion on the Muslim community, made people fear openly practicing their religion or even appearing religious, created community fear, and chilled free speech. And I think it's really important to note that even though this decade-long program was struck down as illegal, it doesn't remedy the harms that have already been inflicted on this community. Next slide, please. And more recently, Immigration and Customs Enforcement has used automated license plate reader technology, cell snooping devices, and face recognition technology to surveil and target immigrants for deportation. ICE agents have mined millions of driver's license photos for possible facial recognition matches, and some of these efforts have targeted undocumented immigrants who have legally obtained driver's licenses. ICE has partnered with companies like Palantir, which has played a key role in separating families and detaining children. Next slide, please. So these examples demonstrate that the creation and use of technology to surveil and harm marginalized groups is not new. However, the institutions that oppress and brutalize the lives of Black, Indigenous, and other marginalized communities are now equipped with tools truly unprecedented in their surveillance power, such as face recognition, location tracking, drones, and other database and AI-based tools. Next slide, please. A key difference between these new powerful technologies and the technologies of the past is that new technologies are powered by truly unprecedented amounts of data. These tools have powerful surveillance capabilities and can even make important decisions about people, including decisions about our healthcare, our housing, loans, sentencing, and bail. And unfortunately, these data-driven technologies often replicate, exacerbate, and legitimize existing inequities in our society. And if these increasingly powerful, invisible, and unaccountable technologies continue to be built and deployed without adequate consideration of the impacts on communities, they will almost certainly continue to exacerbate the structural racism and inequities already present in our society. Next slide, please. So the question is, how do we push for equity in data privacy and equity in the way that technology and technology policies are designed, deployed, and used? Next slide, please. Oh, could you just click through 2 more times? Thank you. Oh, can you go back 1 slide? Thank you, appreciate it. So I think we first need to ask some key questions, some of which include who has the power to decide whether and how to deploy a certain technology, what kinds of regulations are different communities calling for, with what lens and for whom are terms such as cost and benefit designed, what would technology and technology policies look like in a world where those most disempowered in our society wield ultimate authority in making those decisions. Second, I think it's important to recognize that historically marginalized communities are the experts on the impacts of technology and surveillance. And our goal has to be to bolster the ability of communities to share their expertise and exercise decision-making power. Too often, the community engagement processes that are created by corporate, governmental, nonprofit, and educational institutions don't actually serve to equip communities with meaningful decision-making power, but rather function to purposely or inadvertently co-opt community voices and legitimize decisions that have already been made. Task forces, community engagement meetings, and outreach processes that ask community members to draft lengthy reports, provide feedback on or create recommendations, and repeatedly share their lived experiences often demand time and energy without also giving communities meaningful decision-making influence. And community expertise in decision-making processes is often undervalued, while academic, technical, and legal voices are elevated as the only experts and given authority, even when these expert voices don't come from impacted communities and may actually contradict community expertise. Without articulating a specific objective of ensuring community decision-making power, community engagement processes can function as a perfunctory and performative means to shield the status quo, even if it's unintentionally done so. So before we embark on a community engagement process surrounding technology and technology policies, we should really be questioning the norms and assumptions inherent in that process. We should urge our peers, colleagues, and employers to ask questions like, have communities already vocalized their support or opposition to the technology in question? And if so, how will this feedback be considered in decision-making? Another question we can ask is, what authority do historically marginalized communities have in deciding if and not just how a system or policy is implemented? And lastly, in order to build this type of community decision-making power, we need to focus on changing power structures within the different contexts in which we operate, whether we are academics, artists, technologists, educators, lawyers, organizers, or policymakers, or all of the above. We should be continuously working on sharing our institutional and personal power with historically marginalized communities. We all have a responsibility to speak truth to power, to urge the institutions in which we work to cede decision-making authority to marginalized voices, and to share our power with those who have less. I think everyone has a role. Academics can pressure educational institutions to give legitimacy to community voices. Technologists can refuse to build tools that negatively impact marginalized communities. Artists can help communicate complex concepts to different audiences. And policymakers can work on legislation that is driven by and led by communities. Next slide, please. I know Katie and Matt will talk about legislation, but I will just briefly mention 3 key pieces of legislation that we're working on with the Tech Equity Coalition. The first is SB 5104, which would place a 5-year moratorium on government use of racially biased and inaccurate face surveillance technology. And this bill would require that there be a robust and meaningful community-driven conversation to decide if and not just how face surveillance should be used. The second bill is SB 5116. It's an AI algorithmic accountability bill that would require government to make transparent any machines that are making decisions about people, including decisions that are healthcare, housing, loans, sentencing, and bail. And this bill would also prohibit government from using machines to discriminate where it is already illegal to discriminate via humans. And lastly, we are working on a community-driven data privacy bill that was co-created with the Tech Equity Coalition. This soon-to-be-introduced bill is called the People's Privacy Act, and it's being prime-sponsored by Representative Kloba. This People's Privacy Act would require affirmative opt-in consent for any company to use your data beyond the primary transaction that you have requested. And importantly, it would allow individuals to hold companies accountable if and when they violate their privacy rights. we're looking forward to it dropping this week and getting it heard in the House Civil Rights and Judiciary Committee. Next slide, please. And with that, thank you so much for inviting me here to share a little bit about our work today. And please feel free to reach out to me at the email address on the screen. And with that, I'll turn it back over to Katie.
Thanks so much. Oh, thanks so much, Jen. And thank you for that really interesting presentation and background and context on the history of surveillance. I've learned a lot. I really appreciate your coming and sharing that information today. Are there any questions for Jen based on the presentation? If not, feel free to put in the chat. There's some comments in there. And also, if you think of anything, Jen's going to remain with us, I think, during Kelsey's presentation. So if there's other questions that you think of later, please feel free to ask then. So next up, we have Kelsey Fitch from the Future Privacy Forum.
I turned on my video, but I didn't unmute. So hopefully everybody can see and hear me now. Thumbs up.
Yes, sounds good.
Yeah, we got you.
Oh, fantastic. Thanks so much. So really, thank you, Jen, for setting the stage so well. That was a really, really fantastic presentation. And I think a really important piece of grounding in the ways that technology can be used against us, and the importance of having ongoing conversations and checking in with our communities and building equity into all of these systems. That we're, I think we're not going to ever be able to put the technology genie back in the bottle. So thinking about what are the opportunities and vehicles for intervention and change is sort of where I think I want to take us next. So looking forward on privacy and equity in 2021 and beyond. So next slide, please. And so this is just to say, for those of you who don't know us, the Future of Privacy Forum is an independent nonprofit. Our mission is to advance responsible data practices for emerging technologies. We're about 10 years old now, and our advisory board and supporters consist of leading academics, scholars, industry leaders, and advocates from the privacy world. And as you heard at the beginning, I lead FPF's work in the Pacific Northwest. I'm actually based in North Bend. And I lead our work on smart and connected communities, data de-identification, and some other projects. So I'm looking forward to chatting today, but if you've got questions about those things, feel free to follow up afterwards. Next slide, please. So I think just because we had this really fantastic look at the history of surveillance and technology being misused and abused, I think also helpful to have a little bit of grounding on privacy protections in historical context. And this is often surprising to folks, but the idea of information privacy principles was actually first articulated here in the US. And I think it's also something that's interesting or surprising to know that Richard Nixon was the first US president to squarely address information privacy, perhaps somewhat ironically. But really, there's this interesting conversation that appeared in the early 1970s when we started to really crystallize the idea that we needed informational privacy controls. And this is due to the outgrowth of computer technology in the 1960s. Of course, the sort of sudden revolution and the digitization of records, the idea that they would be more permanent, there wouldn't be as much obscurity, they were going to be more searchable as we put things into computer record keeping systems. It was really transformative and led to a lot of concerns about what would happen if we don't have principles and conventions in place. So in 1973, the Health, Education, and Welfare Advisory Committee was tasked with creating recommendations for handling personal data and computer record keeping systems. And they produced a very famous for privacy nerds report called the 1973 Hugh Report. And on Data Privacy Day, hope that all of you could be privacy nerds with me. And they codified this first Code of Fair Information Practices, which have become or sometimes called the Fair Information Practice Principles, or the FIPS, that have been codified, as you can see, in any number of different ways throughout the 70s, 80s, and are still today the foundation for all global privacy rules. And they sort of form the common language of privacy in the US and abroad. And I do believe that they also are fairly instrumental in your newly developed Washington State privacy principles, state agency privacy principles. So this is just to say a little bit that information privacy is part of a proud American tradition, but it is also a very global conversation. These are issues that cut across all nations and all people and all communities. Next slide, please. And part of the reason I give that history is often because we also really hear, particularly when talking to a global audience, that the US has no privacy laws. And in reality, we have so many privacy laws, it can be difficult to keep track of all of them. And that might suggest that they might not all be functioning exactly as robustly as we want, or it might just mean that their technology has really changed over time, and that the law is necessarily lagging the technology, and we're going to continue to keep engaging in this conversation forever. And so what you can see here in this sort of quick chart, this is a subsampling of laws. These is by no means all of them. But you can see first that privacy is a deeply rooted legal concept in the US, right? We have, considerations back to the founding of the US and the Constitution, the federal Constitution. But also privacy laws have really emerged. We sort of see phases or eras of privacy law emerging in direct response to technological changes, especially really rapid technological changes. So the late 1800s, early 1900s, cameras and telephones were a brand new thing and led to the first set of common law protections and considerations around privacy, informational privacy, that is. Moving into the 70s and 80s, you can see concern with computerized records, credit reports, educational records, the sort of idea of your permanent record now being a truly permanent and searchable thing, and sort of a flurry of laws that kicked off. Starting in the 90s, you can start to see laws emerge for data collected online, and how do we deal with this new digital environment? And perhaps now, 2020 and beyond, we might see a new phase of privacy legislation as technology takes another leap forward, particularly in this world of artificial intelligence and algorithmically driven systems. So just to give a little bit of framing in terms of the structures that we have in place today, and if you wouldn't mind taking us to the next slide. Great. So I wanted to do a little bit more framing, because the other thing that you'll hear is not just that US doesn't have any privacy law, but that our regulations are a patchwork. And I think that is very true. And it's important because that gives us a couple of different avenues for intervention and change. We're not just locked into changing laws. We can think about also, how do we protect privacy through technology, through this idea that code is law, as Larry Lessig so famously coined it, and also through social norms. So as you just heard, there's a lot of ways, the most obvious part of our patchwork of privacy as it exists in practice is law, right? We have a lot of regulations and rules and approaches to protecting data privacy in the US system. And this includes consumer protection laws, which are enforced by the Federal Trade Commission or state attorneys general, sectoral laws that provide specific heightened protections for data that's collected in sensitive contexts or from vulnerable populations. So for example, we have HIPAA protecting health data that I think probably everybody here is pretty familiar with. But we also have rules for financial data, children's data, and many more. We have constitutional protections, both at the federal and the state level, against trying to rein in some government overreach. Not necessarily successful, but we also then have case law to hopefully buttress and supplement that over time, and also to struggle with this idea of technology changing. We also have a wide range of state and local laws, where we're starting to see more experimentation with things like anti-surveillance statutes and ordinances, data breach notification laws, common law torts, and then of course things like public records acts and the freedom of information laws that are looking at the collection and use of a disclosure of personal information from another perspective. And then finally, there's a small layer of binding self-regulation also at play here in the US, usually for particular industries who will set their own standards in the absence of a directly applicable law that can be enforced also by the Federal Trade Commission, which currently is the primary privacy regulator here in the US. But I do think it's really important for us to note that we also rely on technical measures to protect privacy and security, and that those technical measures can have the same force or perhaps even a greater force than written laws. And that when technologies and services have privacy baked into them by design and by default, that can be much more meaningful in practice and at scale than promises made in a privacy policy. Fortunately, we do see the development of these kinds of tools for both individuals and for organizations continuing to grow and to allow folks to protect personal data from unwanted collection or processing in a way that wasn't possible in a more analog era. And then finally, I think the equally important part of this patchwork, but perhaps a harder one to wrap our arms around, is the human layer of social norms and organizational ethics that can limit how organizations and individuals use personal data. I think we all have experienced the idea that there are some things that just feel creepy, and creepy is a term of art that we use a lot in the privacy world. But they do things like, if you see somebody snooping on a friend or a colleague's phone when they walk out of the room, there's not necessarily a law against that, but it feels creepy. There's a social norm and a constraint that might stop most, maybe not all, but most folks from violating that norm and that expectation. The sort of interpersonal and person to institutional relationships are really important here. On the other hand, what feels creepy to one person, so an example of Google Glasses, some people found super invasive and were calling people glassholes when they were wearing them and punching people in the face for wearing Google Glasses in public, might be super cool to somebody else. So we saw that trend sort of reverse when Snapchat released some fun new digital recording glasses a couple of years after Google's failed attempt. And I think the only explanation for why there wasn't as much a pushback is that we'd had a real shift in norms in the sort of intervening 4 to 5 years between those two technologies. And even today, there's a lot of things that started very creepy, lots of visceral personal response against a particular technology that have become commonplace for good or ill. And so people have a greater idea of how to respond to them when they encounter those technologies. But maybe perhaps too great or too little recognition for the impact that they might still have. So the trick to norms is that they are very fluid, very subjective, very influenced by things like culture and generation, but also very influenced by things like design choices and deliberate nudging from technology providers. So norms are a key piece of this patchwork in how we experience technology in our day-to-day lives, but they're perhaps less reliable than technological protections or legal protections for reining in potential abuses. And then next slide, please. All right, cool. So this is the framework that I'm going to talk through in terms of, I promised that we were going to look forward, and I am, of course, from the Future of Privacy Forum, so I'm trying to live up to that today. Looking forward at some of the trends that we're seeing in privacy law. So first off, in the US, we're seeing I think the biggest headline news is an interest in passing baseline or comprehensive consumer privacy legislation, both at the federal level and at the state level. So folks likely heard about the California Consumer Privacy Act. The Washington Privacy Act has been in the news for the last couple of years, and we're starting to see states all over the country also start to engage in this. And the idea is that we should have a common backing or a floor for all commercial practices to that patchwork of laws that we have. And important to note that this is just focused on consumer commercial activity, so not meant necessarily to rein in government or to constrain government use of data. Other sets of laws might approach those. But I think this is where we are, interestingly, starting to see more and more consensus develop about what these baseline rights and what obligations on companies should be. So just a quick example is that we've had the right to access or correct or delete your data in your credit reports for 50 years. That goes back to a law from the early 1970s called the Fair Credit Reporting Act. But we're starting to reach the point that says, why shouldn't I have those rights in every digital service? Why just my credit report? And I think that that's a place where we're starting to see consensus. And we're starting to be able to look to Europe where those laws are enshrined and are applicable across all industries, and starting to find that at the core of a lot of these US proposals. There are, of course, still disagreements and nuances to be worked out about the boundaries of those particular rights or some of the other things that we're seeing in this list. But the sticking point today really isn't what those rights should be. Rather, a lot of the debate is how those rights should be enforced, right? I think that's something that we heard from Jen a lot, right? How do we make sure that there are meaningful controls and safeguards and that people can find redress if there's harm? And that's a really big active debate, both at the state and the federal level, that I expect to continue for the next couple of years until either a law gets passed or we move on to the next phase of laws. But because that sort of question over enforcement is holding up a lot of the comprehensive bills, what we are seeing as well at the same time is more sectoral regulation, both again at the federal and the state level, right? So these are proposals to regulate technologies where the privacy harms seem particularly high or the technology is advancing particularly quickly. And so that's some of the stuff that you heard from Jen, right? The facial recognition technologies, automated decision systems or AI or algorithmic systems. We're getting a lot of proposals. Location data and mobility data are also the focus of a lot of regulatory interest right now. Genetic data is starting to see, particularly with the rise of direct-to-consumer genetic testing, so services like 23andMe, we're starting to see more interest in regulating the privacy impacts of those technologies because they're not often very well discussed, but it's genetic information. When you opt into a service, you are actually opting in on behalf of everyone in your genetic line. And that's an interesting thing to think about. And then there's a lot of interest, of course, very timely on COVID-19 data and data collected for the public health emergency or to help track mobility patterns or other sorts of things in this situation. And then a couple of smaller things that we're starting to see in the US are folks are amending state constitutions to enshrine electronic protections, not just assuming that the current protections similar to the Fourth Amendment might apply to electronic data. So Michigan just did this, for example. And we're starting to see a lot of states convene and study these emerging technologies. So there's a big number of task forces studying AI at the state level right now, a lot of reports on the impacts of facial technologies and other things like that. But that's all what's happening in the US. I don't want to lose sight of what's happening globally either, because in many ways, the US is getting outpaced on data protection legislation. So if we look abroad, we see or we expect to pass significant data protection legislation or updates in countries like China and India in the next year or two. We've seen Brazil has recently passed a comprehensive data bill based on the GDPR, that European global data protection regulation. Canada is doing a big update of its privacy framework that we've also looked to in the US, for example, in the past. South Korea and many, many, many other nations doing updates to their data protection rules. So I think it's expected that within the next year or so, more than 50% of the world population will be under a specific data protection law. And that's going to be a really interesting shift in what people's expectations are, how technology is developed, and how do we do international data flows? Because, of course, data flows much more easily across borders than tangible goods. And we're having some struggles thinking about how to regulate that. What happens when you do want to send data across an international border? But on the other side of that border, there's domestic surveillance systems that would be inappropriate for your community. And so there's a tension right now between the US and the EU over exactly that question. And we expect to see continued conflict over the idea of data flowing internationally. We're also starting to see data localization laws pop up in places like Russia that would explicitly limit the ability of data to flow over borders or to be stored abroad. So there's sort of both an expansion of data protection legislation and perhaps a contraction of the data flows themselves that's being worked out on a global level. The other thing to note here is that we are getting all of these new laws are coming with new privacy regulatory agencies. So new enforcement is coming down, new guidance is coming out of those, a new interpretation of the law. And to the extent that US laws are borrowing from global frameworks like the one in Europe or elsewhere, that sort of interpretation and guidance and practical experience is invaluable. And just to, for example, the city of Rome, I think within the last week or so was subject to a 500,000 euro fine for over-processing data from its populace. So that's the kind of situation and kind of precedent that's really interesting to folks here in the US. All right, but that's the trends in the law. Next slide, thank you. You read my mind. So let's talk also about trends in technology development and trends in the development of social norms, because I think those are also super interesting and important. And I don't want us to miss out on the opportunity to see those as opportunities to bake in more, thinking about the development of those technologies before they cause harm, thinking about what kinds of norms do we have in the world, and how do we ensure that technology and the benefits and the risks of technology are being are accruing equitably across our communities. So first, quickly on code and tech, we are really starting to see the next phase of technological controls to protect privacy. There's a lot of technology that you heard that's pushing against privacy, and that's certainly happening, but my focus today at least is on the things that are hoping to give people more control where that's possible. So lots of individual privacy controls starting to be used at scale in a way that they hadn't perhaps a decade ago. Some more global opt-outs being developed, folks using ad blockers, people using encrypted messaging services. The encrypted messaging app Signal just saw its rates skyrocket over the last month or two. I think particularly folks heard about services like WhatsApp, perhaps sharing data back to Facebook. And so thinking about people are being for what control they do that individually. But of course, we don't want to put the burden of self-protection solely on individuals. That's not an equitable outcome. People are busy and tired and don't have the capacity to keep up an arms race against all of the ways that their data might be collected. So the other thing that I'm really interested to see is the development of platforms implementing and requiring privacy controls. And we see this particularly in the app stores. So both Android and Apple now require privacy policies for all of their apps. They are randomizing some of the device identifiers that used to be used to track individuals as they moved through public spaces. And recently, Apple is going to cause a sea change in some of the digital advertising landscape by requiring opt-outs of targeting or tracking by app. So that's going to be really important, that with the flick of a switch, these platforms can really raise the level of privacy protection. That does come, of course, with some concerns about the power that these organizations have to unilaterally change privacy settings. But it is an important safeguard and one for us to be paying attention to. There's also the development of privacy enhancing technologies. There's a lot of research going on in academic centers and at the federal level among the statistical agencies. The US Census Bureau has really been pioneering things like differential privacy that offer greater privacy protection while still preserving statistical and analytical insights. And they have, these are all based off really sophisticated cryptography and mathematical proofs. So that you can prove that privacy has been safeguarded. It's not just a trust me act. These are, really sophisticated mathematical models that you could use. Haven't been used to scale much, but are increasingly going in that direction. I think particularly, as I said, by the help of folks at US Census and others. We're also interestingly seeing the development of an entire industry providing technology management services to organizations and to enterprises rather than to individuals. So there's billion-dollar companies offering consent management services, risk assessment services. And that's a really, really new development. But that suggests that privacy has become somewhat of a competitive differentiator. And that might hopefully encourage technologies to be built with privacy by default and privacy by design in mind, in the hopes of achieving better outcomes. So a lot of stuff going on the tech front, but I think the social norms is more intriguing ones because we've lived through this. I think we all have a more visceral understanding of the sort of changing attitudes towards privacy. So on the one hand, we are seeing more public engagement on privacy. There are more local committees and public engagement happening, like Jen was mentioning. There's an increase in digital activism and public interest technologists that are hoping to do watchdog functions on a lot of the development of this technology. So on the one hand, there's more interest in activism. On the other hand, the general public feels concerned and confused and out of control. And that's a pretty persistent struggle as the tendrils of the digital economy continue to reach every aspect of our lives. There's a feeling of powerlessness as an individual that often comes along with that. And then that's the thing that we are still struggling to address. Part of this, though, I think the really interesting case study is when COVID-19 hit and we all moved our lives online and we worked online and we socialized online and we sent kids to school online, we really triggered this need to quickly, rapidly develop new social norms, right? Folks remember back, a little under a year ago, the first month or so of Zoom or Cisco or Teams meetings that you were holding from your home or from a virtual environment rather than the office, there were questions about, is it appropriate to have a pet in the background? How do you block out a child who needs your help or a family member who needs your help? How do you carve out time and draw these boundaries? And when do you wear pants or when do you not wear pants when you are working solely from home? Is really tough questions that we had to rapidly evolve as a society. And we did. And we saw a lot of guidelines and etiquette best practices and memes and comics and all sorts of other stuff as we figured this out collectively. The risk, though, is that a lot of those sort of initial norms ended up having inequitable impacts. So we saw a lot of guidelines for students to be alone in a room with a clear background, have your video and your audio always on. But we learned really quickly that that was going to expose children who were in lower socioeconomic situations or who didn't have reliable internet at home to bullying and to lack of opportunities. And so we've had to do new adjustments. We've had to shift those norms to be more equitable, even if that means that the services themselves are less efficient. And so going through that process collectively, I think, is a really good encapsulation of how fluid and how important the interpersonal layer of privacy protection is, but also the importance of being deliberate about equity and being deliberate about the ways in which these technologies might not impact all of us the same. So next slide, if you wouldn't mind. Oh, awesome. And so that's just to continue this thread. The top trend in building on the things we're seeing in law, the things we're seeing in technology, and the things we're seeing in norms, is that privacy is no longer just about privacy. When you see conversations about privacy, 10 years ago, 50 years ago, it's always been the case that privacy means many different things to many different people. Everybody's got their own sort of conception of what it feels like to have their privacy violated. We don't have a definition. I work in a profession, in the privacy profession, that can't define what it is we all do. And we laugh about that on Data Privacy Day, so I invite you to laugh with us. But this is, I think, the heart of privacy is that it is subjective. It's not going to be something easily defined, but that it is a fundamental right. And it's the foundation for other fundamental rights as well, right? It's really hard to have truly free expression or true self-determination and autonomy if you don't have the privacy to make those decisions for yourself. But historically, really focused on individual rights and control and identities. We haven't it's been much more in terms of protecting the data rather than thinking about those other interests that are impacted by privacy. But over the last couple of years, and I think especially going forward, we really do see privacy linked not to concerns about security or protecting data, but to a lack of trust and a power discrepancy, as Jen was describing, and concerns around fairness. That sense that you might be in control of whether you click yes on an app asking for your consent, but you don't have any ability to negotiate those terms. You feel powerless, and that is, for the folks who are privileged enough to be in a position to be able to access that service in the first place. And that's not necessarily always the case. So what we're seeing is this sort of privacy and a lot of other considerations being part and parcel of the same conversation. So privacy is now wrapped up in the same conversations legislatively, in terms of technology development, in terms of norms, as things like equity and ethics and civil liberties. So you'll see a lot of privacy conversations that are really about anti-discrimination or about disparate impacts of technologies. We're also starting to see conversations about dark patterns or deceptive design, right? That sort of using nudges and norms against individuals to get them to reveal more information than they might otherwise want to. But also things like filter bubbles, internet freedom, and content moderation that historically have not been part of the privacy conversation. There's also an intersection with other digital regulatory trends. So competition and antitrust and privacy are really entwined right now. Digital markets and global trade are also a big driver of these impacts, and I think can't be understated, the influence that those have, particularly at the federal and the global level. But fortunately, we're also able to think about things like group privacy harms and to pay more attention to the inferences and the profiling and the tracking and observation of individuals that they might not be aware of, but might have a chilling effect nevertheless. And so I think all of this is part of this new trend of privacy plus other considerations. And I think that's a really encouraging development. But it does, unfortunately, raise some tensions that we haven't quite figured out how to deal with. And so I flagged a couple of them here, but one that folks might be familiar with on this call is the extent to which we have open data, programs and public record laws that are intent to shine a light on government and to increase transparency about government. But they often also put attention on individual privacy because the government holds a lot of data about individuals. And so how do we square that? How do we have both protection for people and transparency for government is a really challenging thing that we haven't found a good result for. Similarly, that question around equity and representation for vulnerable groups. What do you do when there's a population that is both undercounted and underrepresented in things like the census, in things like local government, in things like other public services, but is also already over surveilled? And so that the answer isn't finding new ways to surveil them, but it's finding some alternative route to addressing both equity and privacy. So these are really big challenges that we don't have good answers yet to, but that I think good to pay attention as we expand beyond sort of traditional privacy and towards other aspects, to have those tensions in mind and to think about what are the public policies that we want to enshrine here. And then one more slide, because I just really like this next quote. I think this sums it up really well from two great privacy scholars, Woody Hartzog and Neil Richards. Just to note that if you ask people about the chances of our privacy law passing in the last 10 years, most of us would have said, like, it would be nice, it's not ever going to happen. Over the last 2 to 3 years, that's really shifted. There is really the sense that our moment for privacy has come due, and that we are confronting a constitutional moment with privacy, and that we need to make sure that it's reflecting not just how we protect data, but how we protect people. I think that's a really essential walk away from Data Privacy Day. And then I know I'm running, I think I'm out of time, but one more slide just to flag. I think you guys will have these slides afterwards, but these are the particular issues I'm keeping an eye on, so I don't need to go in now. But if you're looking, if you've got really engaged by privacy during this conversation, or you're already super engaged on privacy, these are the kinds of things that I think are super interesting. I'm happy to chat about during Q&A. Or afterwards. The next slide, I think, also has my contact information, and welcome you to reach out at any point. So I think that I'm gonna finish up there and turn it back over to Katie.
Thank you. Thanks so much, Kelsey. I learned so much from your presentation as well, and lots of new terms, all the way from homomorphic encryption to glass holes. So appreciate it. So there is a question. There's a couple of questions that come through the chat that I wanted to pose to you. And I think this first question might be a little bit more directed to Jennifer. It says, Jennifer said getting more community input is one way to build more equitable, privacy-friendly data practices. Are there any good examples of agencies or organizations doing this that is involving communities and deciding how their data is gathered and managed? So is Jen still with us?
Yes, I am. And Katie, do you want me to turn on my video or should I just?
Sure, that would be great. Thank you.
Sure. Great. I think that's an excellent question. And just to answer the first part of the question, I think getting community input is really important. But as I mentioned, it's not just about getting that community input, but how that community input is treated. Because if you're gathering community input, but not incorporating that input into decisions that will impact communities, then it drains a lot of community energy and resources without giving people meaningful decision-making power. In terms of examples of organizations or agencies doing this, I mean, I think I can just share what we are trying to do at the ACLU with our Tech Equity Coalition. And that has been engaging with the Tech Equity Coalition before any words are put on paper regarding a strong statewide data privacy law. And I mentioned in my presentation that we are supporting the People's Privacy Act, and that's an example of a piece of legislation that, you know, before any words were put on paper, we virtually sat down with the Tech Equity Coalition and we brainstormed what kind of world we wanted to see. A world in which people's data would be protected, a world in which data could be used in some ways, but in some ways data use would be prohibited. And at every step of the process, we checked in, we made sure people's ideas were represented and priorities were put into the legislation. So I think that's just one example of what we've been trying to do in ensuring that people have meaningful community input. But I think that as we do this advocacy collectively, we're all in the continuous process of learning how to best share our power and lift up community decision-making power. And I would, you know, if Kelsey has other examples of organizations or entities doing this, I would also love to hear. And anyone else listening to this, if you have examples you'd like to share of organizations you've seen model really good practices, please do send them my way. But thanks for that really great question.
Yeah, I'll just throw out a nod to City of Portland. I think did a really similar effort when they were drafting two policies around facial recognition technology over the last year. They really started with local community input and unconference style engagement, and then used that as the basis for drafting those policies, running them through City Council, and just they've worked really closely as a city between the sort of smart city effort and the Division of Human Rights have been working hand in hand with the community throughout that process. So I think second to all of the great things Jen said, but if you're looking for another example, City of Portland, I think big thumbs up.
So this is a question, I think for you, Kelsey, or Jen, feel free, but what trends do you see in holding institutions and industry accountable when it comes to enforcing the voluntary or regulatory standards designed to protect privacy?
Yeah, so I think this is a tough one. This is, for folks who aren't familiar, the way that this works in the US is that the Federal Trade Commission has what's called Section 5 authority to enforce deceptive or unfair acts and practices, commercial acts and practices. This includes most, not all commercial practice in the US. So there's a couple of carve outs for things like logging industries and airlines and nonprofits that are historical remnants. But what happens is if you are a self-regulatory industry and you draft a code of conduct and you say on your website, you say in your materials somewhere that we pledge to hold to these certain guidelines, and if you violate that, that's a deceptive act. The FTC now has authority to bring an enforcement action against you. So we don't see it happen very often. We do have a couple of specific cases where entities have violated those standards and have been enforced by the FTC. Much more common is that the self-regulatory body itself does the enforcement. So there, for example, the Network Advertising Initiative is a self-regulatory consortium of advertising agencies and networks in the US. They have a code of conduct, organizations that sign up to follow and to be part of that and to follow those guidelines, do regular check-ins with the NAI itself to ensure that they are in compliance with the code. So you get both sort of that self-regulatory enforcement, and if that's insufficient, the Federal Trade Commission can step up and back some of that. So we've seen a couple of examples. I think Trustee had a COPPA compliance seal program that has an enforcement action against it a number of years ago. It's pretty rare though, but this is also to say that the FTC has fairly relatively limited capacity. So as one of the things that you'll see in all of the federal privacy bills is to give the FTC more capacity to bring more cases. So I think we see a fair amount of that. I also start to see, if we look to Europe, there's provisions for codes of conduct built into the GDPR. Those need to be approved by a data protection authority before they're valid. And we're a couple of years into that framework. We're starting to see some of those codes proposed. I'm not sure if any have been given DPA approval yet, though. So really interesting question. Jen, I don't know if you have any insight onto some of the self-regulatory stuff, or if you've seen other things in the space.
Kelsey, I think you did a great job covering that question. And just from the ACLU's perspective, I'm not on trends specifically, but we are, as I mentioned, we are really looking for a privacy law that is enforceable by individuals, and that includes a private right of action. That's something that we think is really integral to making sure that any rights in a privacy bill are really meaningful and empower individuals and consumers. So thank you, Kelsey, for sharing, answering that question, but I just wanted to add that in there.
And to piggyback on that, there's another question about if fines are enough for violations, or is the SOX model something to think about, for example, holding CEOs and leaders responsible up to and including criminal charges for failing to ensure due care and due diligence?
Yeah, that's a really interesting. We've seen that proposed in maybe one or two federal bills, I think out of Senator Wyden's office, but I'm not 100% sure, so don't quote me on it. I don't think it's something that we've seen get widespread interest. I think we look to the GDPR and we say that if the fines are sufficient, then they do seem to be having a significant impact. And so the GDPR model is that it's, I think, 4% of global turnover or 20 million euros, whichever is greater. So that's sort of the standard that's being weighed right now. And so I think that's lots of options for enforcement. And I think one of the things that, as I alluded to, enforcement is one of these things that is really holding us back from being able to have a comprehensive law. There's just a lot of folks dug in on either side, whether that should be a private right of action as sort of a key remedy, or whether it should be exclusive enforcement by a body like the Federal Trade Commission, or California is standing up a new California Privacy Protection Agency, or in other state proposals, it would be the state AG's office. Lots of pros and cons to all of these things. I think FPF's perspective is that probably there's a mix of enforcement remedies that make sense. It's not a one size fits all. You're not limited to one or the other. So let's be thoughtful about where, we've had a lot of success for private rights of action for civil liberties violations here in the US. But if there are things that are more procedural violations or that are less impactful on individuals, that might be appropriate for, or particularly where there's things where the technology is quite complicated and the risks and impacts are difficult to understand. There's real value in a regulatory body like the FTC or a standalone data protection authority that has experience and has competency and has built expertise in these technologies and in these business models over time. So big open question. There are folks thinking about fiduciary models, thinking about holding CEOs and others liable, sort of that question of like, who goes to jail if this goes really wrong? Not any really good consensus answer on that yet, unfortunately.
Mm-hmm. And this has come up a couple times. Do you think, or will the USA or US pass a national law like GDPR that guarantees comprehensive privacy protection?
Oh, I hope so. I really do think that privacy is the kind of an issue that I want to preserve some ability for states and localities to address the priorities that are really important to them, and to, thinking of a federal law probably as a floor and not a ceiling. But I think consistency is really important. And it enables businesses of all shapes and sizes, and that people's expectations for privacy don't stop at a geographic border. When I leave Washington and I cross into Oregon or Idaho, I don't think that my data should be treated differently. I don't necessarily interact with my apps and services differently. And so I think it's important to have a comprehensive framework that applies. I think the interesting note about the GDPR isn't just that it crosses all industries, but that it applies to the private and the public sectors equally. And that I don't think we're likely to get in the US. But I also think would be really useful, because again, people's privacy expectations engaging with systems aren't so easily bucketed based on industry or sector or technology. So I think useful to have a common framework. But that's my perspective. Jen, happy to, if you've got other thoughts, or if you're more optimistic than me. I think the more that we see competing state models, I think the more likely it is that we get a federal baseline law. But there's sort of a momentum that needs to be seized. So we might miss the moment here as we have in the past.
Jen?
Oh, Kelsey, yeah, I I agree with you that a comprehensive federal privacy law is really important and necessary. And I also agree that I don't, think I would use my apps differently or technologies differently depending on which state I'm in. But I think one thing you said really stuck out to me, and it's that we don't want a weak federal privacy law that sets a ceiling, not a floor. So if we hope to see, if we do see a federal privacy law, we hope that it is really strong and it doesn't preempt states from passing stronger laws where appropriate.
Thank you. Well, I think we've touched on all of the questions that came in. So I want to thank both of you so much for your presentations today and all of the expertise and knowledge that you shared with us. So I just want to thank everybody for today. Happy Data Privacy Day, and have a great rest of your week. Goodbye.